Ready? Start. Having heard the learned counsel for the parties and on perusal of the record of the case, we are constrained to allow the appeal, set aside the impugned order and restore that of the learned single judge as indicated below. Stop. In our considered opinion, the approach, reasoning and the conclusion arrived at by the learned single judge was just, legal and proper as against that the division bench for the reasons mentioned here in below. Stop. Firstly, it is not in dispute that the original allotment of the flats made by the board was in favor of the university. Stop. Secondly, it is also not in dispute that the university had made substantial part payment to the board pursuant to the allotment order, which the board had accepted. Stop. Thirdly, it is also not in dispute that the writ petitioners were the employees of the university, and therefore they were allotted flats by the university by virtue of their employment conditions. Stop. In other words, the writ petitioners came in occupation of the flats through their employer, that is university. Stop. If they were not in employment of the university, they would not have been able to occupy these flats in their individual rights at that point of time for want of any privity of contract with the board. Stop. In our considered opinion, the writ petitioners, that is respondent numbers 4 and 5, right to remain in lawful occupation of the flats could subsist only so long as they were in the employment of the university, and that too on payment of house rent fixed by the university as per their policy. Stop. In other words, the writ petitioners could exercise their right of occupation qua the university only during their service tenure, subject to fulfillment of the requisite terms and conditions, and their right of occupation was terminable on their service tenure coming to an end. Stop. The day on which their services came to an end, whether due to their tendering the resignation, or on attaining the age of superannuation, or for any other reasons, their right to continue in occupation of the flats came to be an end. Stop. Their possession in the flats become unlawful and unauthorized. Stop. They were under contractual and legal obligation to hand over vacant and peaceful possession of the flats to their employer, that is the university, so as to enable the university to allot the flats to other employees who were eligible for allotment. Stop. It is not in dispute that the writ petitioners, that is respondent numbers 4 and 5, had retired long back from their services, and yet they retained unlawful possession of the flats in